pursue this theme very slightly further. The Attorney General's final paragraph essentially says that unless you can show breach of faith, rather than simply intractable differences, nothing has changed, and the UK has no intentionally lawful means of exiting the protocol arrangements save by agreement. And when it comes to whether or not the difference is due to actual breach of faith or is simply intractable differences, that isn't really a question of fact. It's a question of opinion as to whether what is in the mind of the people undertaking the negotiations. So what confidence can we have that actually breach of faith stands any chance of being upheld? The EU simply turn around and say, no, we're trying to find a solution, we just don't believe that what you're suggesting works. That becomes an intractable difference.
Yeah, so what you quite rightly draw out is a distinction between whether there has been bad faith or whether both sides are still negotiating in good faith but have not got to the outcome.
Well, no, intractable differences means you've stopped negotiating. It means there are intractable differences. That doesn't necessarily mean bad faith.
Well, you can have a situation where both sides are still negotiating in good faith, and that's why the way out of that is through the arrangements, and that's what it says. But the central question that came through the debates we had in the Chamber was this sense that the EU were going to act not in good faith to reach an agreement with the United Kingdom. The charge that many colleagues in the House had was the opposite, was that the EU were going to act in bad faith, and that the backstop was this vehicle to distort the negotiations and trap the UK. Now, if you trap the UK, you are de facto acting in bad faith. You are trying to distort the talks for negotiating advantage. That's
but you have to prove
concern.
Bad faith. And if the EU aren't going to say, actually, we're never going to agree to anything you come forward with, because that would be bad faith. But if the EU say, look, we'd love to find a solution, we simply don't agree with you about the viability of the one you're proposing, that is an intractable difference, and it means we can't leave.
Which is why, and I referred to it, and it's paragraph 9 of the attorney's advice, where he addresses the fact that if de facto the relationship has become permanent, then by its nature it is not temporary. Now, if both sides, one's got to, I think it's worth taking a step back, both sides have given a commitment to put a future economic partnership in place by the end of 2020. The question then is, at what point does that no longer become temporary as you go past that? Now, as I say, the aim is not to go into the backstop. That is what the work stream, which I did with a number of colleagues in the House, in terms of the alternative arrangements, and that's where we made significant progress with a clear time frame and a commitment from the EU on that. The question, though, is beyond what both sides have agreed, at what point would it become de facto permanent? And at that point, to what extent does that mean bad faith is occurring? Now, if both sides are negotiating in good faith, then of course that negotiation will continue.
I'm afraid, I don't want to pursue it, all I would say to you, Secretary of State, is that the conclusion of the Attorney General's conclusions, which is the last paragraph of his letter, reads very much as if nothing actually has changed. And obviously I'm not a lawyer, I'm waiting for advice from my colleagues who are lawyers, but that final paragraph is pretty terminal.